Hello, everyone. This is Tom Fox, and I'd like to welcome you to another episode of Life with GDPR. This is the podcast series where, together with Jonathan Armstrong, partner at Cordery Compliance in London, we take a look at data privacy, data protection, and all issues related to GDPR, the English data protection law, and data protection and data privacy laws in the United States. It's a podcast that every compliance practitioner needs to be listened to and be a part of the discussion going forward for this most important issue in compliance today. I'm Tom Fox, the Compliance Evangelist. Life after GDPR is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for another episode of Life with GDPR. I am joined, as always, by Jonathan Armstrong, a partner at Cordery in London. Jonathan, welcome.
Thanks very much, Tom.
Jonathan, we had a case involving Jehovah's Witnesses in the United Kingdom, specifically around data privacy and data protection that I found very interesting. Jehovah's Witnesses, of course, are well known, certainly in the United States and in the United Kingdom. The witness part comes from they actually go door to door and witness for their belief in religion. They have been at the forefront of religious freedom cases in the United States. So I was therefore very interested that they're at the forefront of what appears to be a very interesting case around data privacy. So the requirements now that companies provide subject access requests. So with that somewhat long-winded introduction, I was wondering if you could give us the background to this case.
Yeah, sure. Happy to. It's actually starts off as a Finnish case. So what happens is, as you've rightly said, the Jehovah's Witnesses are known for their door-to-door visits to people. And what happened is a community of Jehovah's Witnesses in Finland went door to door, collecting information from people, which they and those groups had various memory aids to make their outreach more efficient. So one of them, for example, was a map of a particular locale, and they'd draw things on the map. So they'd effectively, they're technically called suppression lists, but it's sort of the wrong description when you're drawing on a map in some respects. They would just draw on the map and say, these people don't want us to visit, but equally they might write in information regarding some people who might be targeted for repeat visits on the basis of potentially being receptive to that happening. And the Finnish Data Protection Authority, for the benefit of all Finnish speakers, I'm not going to attempt to pronounce what they're called, but the TT, let's just call them the Finnish Data Protection Authority, decided that this outreach did come within data protection legislation. This is the earlier Finnish Act before May, when the GDPR came in. And they said that the Jehovah's Witnesses had to comply with this Finnish data protection legislation. The Jehovah's Witnesses said they didn't think that was correct. And what happens in these cases, as we've mentioned on other podcasts, is where an issue of EU law is involved, the Finnish courts can refer the matter to the European court, who look at at who's correct and the correct interpretation of EU law. In this case, it was the Data Protection Directive, which is the predecessor of GDPR. But on the basis of most of what they decided, the case is useful for GDPR as well. So the court looked at a few things. First of all, the Jehovah's Witnesses were trying to say that it came within what's often called the domestic purposes exemption. So if I have people round to my house for a dinner party and it's just to socialize, let's say we decide to get big Texas steaks and put them on the barbecue, and I say, Tom, how'd you like your steak? If it's just between us and it's our part of our domestic household, the fact that you say, as as rare as they come to me. I can record that because it's purely for the domestic purpose. But the court said here, this was beyond a domestic purpose. It wasn't just a household activity of either the Jehovah's Witnesses or the individuals who made up that group that were going knocking on doors. So they've said that the domestic purposes exemption didn't apply. And that's consistent with many of the cases that we've seen recently. There's one involving surveillance cameras, for example, monitoring a neighbour. We know that as a general rule, the courts don't like the domestic purposes exemption. And again, as a general rule, that exemption is narrower than most people think. If you're doing some sort of commercial activity, even activity on behalf of a not-for-profit, then it's unlikely that the domestic purposes exemption is going to save you. Secondly, they said that the data was covered by data protection law even in hard copy format. Now, we know all of this already. We know that data protection law applies to manual data processing, but the law as a specific says it only applies to hard copy data where it forms part of a filing system. Now, again, the courts have generally been pretty ready to say that if you can retrieve it, then it's part of a filing system. So things like filer faxes, which I know were popular, I don't know, amongst the Gordon Gecko generation, then they were caught by data protection law, the last iteration of data protection law. And maps are the same. If you can get them back again and interrogate data on the basis of that hard copy map, then that's going to fall within GDPR. And that's particularly interesting, of course, when you look at things like internal investigations, when you look at things like e-discovery, because it's quite hard to ingest data like that, particularly if it's handwritten on, huge maps into any type of system to interrogate it. So that's a particularly interesting bit of the case, I think, and will frighten, I think, some commercial concerns, particularly if they have their people do large volumes of hard copy notes, because they'll have to potentially show those that data under subject access requests. And they'll have to invent or tailor some sort of a system to enable that data to be disclosed to the individuals involved. And then maybe the last bit that's interesting is that the court ruled that not only were the individuals data controllers, so subject to data protection rules, but also the parent religious community, if you like, was also a data controller jointly with its members. Even though the parent body, if you like, didn't have access to the data, even if it didn't tell its members what to do, give them written guidelines or instructions, it could still be a data controller. And it's that bit, I think, that's probably the most interesting bit. We've had a lot of debate as to who's a data controller and who's a data processor. Now, you'll remember that both data processors and data controllers have more to do under GDPR. And in the past, data processors could almost wash their hand and say, we're just a processor. We don't have any responsibilities under the data protection legislation. That's not true anymore. But equally, a lot of people have said, well, let's say it's, I don't know, a helpline. They might have said in the past, well, I'm obviously the data controller because it's my employees, it's my people who are going to phone in, and the organization handling the calls is a data processor. But distinctions like that get more blurry under the new legislation, particularly because of all these court decisions. And just because you are the data controller doesn't mean that the other party is the data processor. And just because they're the data processor doesn't mean automatically that you're the data controller. You can have a situation like in the Jehovah's Witnesses case where there's more than one data controller. And that, I know, is something that large organizations are really struggling to get their head around. And it's always a very technical point and requires a bit of effort. And obviously, you can't just say in your contract, you're the data controller and I'm the data processor. You can't say that in a memorandum of undertaking, which many people do, because the regulator or the court can always decide that even though somebody says they're not the data controller, they are. And that's what happened in this case. So it's quite easy to become a data controller without realizing it. For example, we've done some work with a firm of a barrister's chambers, and if they do a divorce case where they take a file from the wife in the divorce, let's say, and they decide which data to shred and which to keep, then they become the data controller as well. So organizations have to think very carefully, particularly when they're getting things like spreadsheets via email, when they're getting a large volume of emails. They need to work out what their responsibilities might be. So I think it's an interesting case for a lot of reasons. It isn't the first data protection case to involve religion. I had a case called Lindqvist, which very early data protection case at an EU level, which looked at data held in connection with First Communion. But it's clear that the religious communities are subject to GDPR just as any other organization is.
So with this case, particularly on the data controller issue, do you find that you gave the example of a law firm in litigation, but is this something that clients are waking up to or companies are waking up to who may not have previously saw themselves in this position, or do you really find this case to be not so much limited on its facts, but people just really not seeing the wider applicability?
Yeah, I think you're right. I think it is of wider applicability. It's not isolated. We've had a Facebook case that was a referral from one of the German DPAs or through the courts, German DPA through the German court system, then to the European court, which decided similarly in that case an educational institution had pushed some students and staff onto a Facebook page for them to communicate with each other. And the court said there that the educational institution was also a data controller as well as Facebook. So they were responsible, theoretically at least, for Facebook's advertising practices, what they were doing with the data, et cetera, because they were both data controllers. We've had a data breach case involving Morrison's, a large retailer here, a little bit like Walmart, where they had somebody from their internal team effectively steal data. He was a data controller because he then copied it and decided what to do with it. But Morrison's were a data controller at the same time because they, it was their employees and they owned that relationship. So it's not a case in isolation on the data controller point, but equally, a lot of organizations, they probably struggle with this the most. And a lot of them have assumed that, because you're wearing hat A, then I have to wear hat B. But that's always, to my mind, been a false assumption. And the courts have underlined that in these three cases, that you can have a situation where everybody in the chain's a data controller. And obviously, the difficulty of you assuming you're not a data controller is you might not have processes in place to report breaches in time, to respond to subject access requests, et cetera, and that's going to get you into trouble if you don't work out exactly what you are in any given situation.
Well, Jonathan, unfortunately, we're near the end of our time, but this is really a fascinating case. Obviously, Jehovah's Witnesses are, like I said, well known both in the United Kingdom and the United States, continue to be making some law, and as always with these cases, a much wider applicability for the greater commercial communities. So thank you, and I look forward to continuing the conversation.
My pleasure, Tom. Thank you.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of Life with GDPR. If you have any questions, you can email me at tfox@tfoxlaw.com. You can email Jonathan at jonathan.armstrong@quarterlycompliance.com. Hope you'll join us again for another episode of Life with GDPR. Life with GDPR is part of the Compliance Podcast Network.